Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 201. The name of the case is CIT and another versus SR India Private Limited. This case has been reported in 448 ITR at page number 417 and the matter has been decided by Karnataka High Court. The date of the judgment is 31st January 2022. In this particular case, the facts of the case are like this. There was a survey on the Assessee under section 133A. It was a tedious survey. In the survey, the documents were found which shows that there are a number of lapses on the part of the Assessee regarding the tedious provisions. The first lapse was that there were some payments on which the TDS should have been deducted, but the Assessee had not deducted the TDS. The second type of default was that the TDS was deducted and deposited at a lower rate than what was prescribed in the income tax provisions. And the third default was that the TDS was deposited late. The assessing officer passed the assessment order by fixing the tedious liability of the assessee. There is section 201 subsection 3 which lays down the period of limitation. The limitation period for passing the order under section 201, which was relevant for the assessment year for which the matter was pending for the assessing officer, was 2 years. But with effect from 2014, this period was increased from 2 to 7 years. Section 201 subsection 3 says that the assessing officer has to pass the order within 2 years or 7 years from the end of the financial year in which the assessee has filed his TDS statement. In the case of the assessee, the relevant assessment year was 2008-9. The period of limitation was applicable was 2 years. But in the present case, the assessing officer has passed the order beyond 2 years. So the assessee was contesting on this issue that the order is time barred. But the learned assessing officer passed the order beyond the limitation period. When the assessee went to the CIT appeal said that this order is not valid and quashed the order. The department moved to the ITAT and ITAT also gave relief to the assessee. So the department was before the High Court. The High Court said that there is no doubt that the statement of TDS has been filed by the assessee. The period which is applicable to the assessee is 2 years, not the 7 years. So the order passed by the assessing officer is time barred. The court said that by bringing the amendment, the limitation period cannot be increased from retrospective effect. In this case, the court also gave reference to the two very important decisions of the Supreme Court. Those decisions are SS Gadkil and Lal versus Lal and Company, and second is KM Sharma versus ITO. In this case, it was settled that limitation period under the Act is not a period of limitation, but the same imposes a fetter on the power of the assessing officer to take action under the said provision. Apart from this, the court also said that a right accrued to an assessee and subsequent amendment thereof could not have revived the period of limitation and take away the vested right accrued to the assessee. The simple meaning of these technical lines is that by bringing the amendment, the legislature cannot revive the period of limitation from 2 to 7 years. So in this present case, the assessee get its case on the technical ground of limitation that the order passed was not within the time limit and it was time barred. At the end of this video, once again I am repeating the name of the case. The name of the case is CIT and another versus SR India Private Limited. And this case has been reported in 448 ITR at page number 417, and the matter has been decided by Karnataka High Court. Thank you, friends.